on the map when he, as a Delhi High Court judge, read down Section 377. It was the landmark ruling on homosexuality. And now Justice AP Shah has come out with another progressive thought with his Law Commission report that recommends that the death sentence should be abolished except for terror cases. Justice AP Shah is here with us. Thank you for joining us here on Agenda, sir. You know, I just wanted to start out, and we of course have a whole audience of law school students who are also very keen to ask you lots of questions about this progressive report that you've come out with. The first thing I wanted to of course ask you is that in your report, out of the 11 members, 3 have dissented. Now, the fact that the 3 people who've dissented in the report, they are all government officials, at least 2 of them. One is the law secretary, one is the legislative secretary. Is it an indication that the government is going to reject your recommendation?
I'm not sure whether the report would be finally rejected by the government, because the report will be considered at various levels. Of course, when the secretaries, 2 secretaries, the legislative secretary and the law secretary, felt that they were of the opinion that death penalty should be retained. And in a democracy, dissent is really, has to be there. It's a very sensitive subject, and there may be different views on that. So we have really 10 members in the commission. Out of 10 members, the 2 secretaries and Justice Usha Mehra favored the retention of the death penalty, and 6 members supported the abolition. Of course, it is what is recommended is a gradual abolition. The recommendation is that it should be abolished for ordinary crimes, but the ultimate goal should be abolition for all crimes. And it would be done eventually, and we expect the parliament, the government, there would debate this issue. There would be principal debate, rational debate on the
you know, one of the things, Justice Shah, that you mention a lot in your report is the pressure which in the previous Law Commission, which dealt with it, which was the 35th Law Commission, which was 35th report, which was in the 60s, of course. One of the things that they went by when they retained the death penalty, and perhaps it seems even now very, very significant, is public opinion. Do you think it is public opinion which may make lawmakers and other government people oppose what you're saying to get rid of the death penalty altogether?
Of course, public opinion is a very relevant factor. I'm not denying that.
It is relevant.
And it is relevant. I cannot say it's not relevant. Government has to take into consideration the public opinion, but it's very difficult to gauge the public opinion. First, the government or anyone must try to find out the informed public opinion. When you say whether you ask a question whether death penalty should be retained or it should be abolished, the answer may, if it is the person to whom this question is put,
yes,
is aware of the various aspects of the death penalty, he may not support the retention of the death penalty. But therefore, public opinion is a very elusive thing. For example, in France, the public opinion was 67% rather was in favor of retention of the death penalty. But the then President de Gaulle and the Minister for Justice, Mr. Robert Badinter, they decided to take a lead and abolish the death penalty. And it simply abolished.
So it was a decisive leadership.
Decisive leadership.
So do you think we are capable of that decisive leadership?
Of course, I am sure that we are capable of guiding the nation.
Sir, when you talk about public opinion, I have to ask you, because this has just come about at a time, and in the past month while you were preparing this report, I know you had a whole day's conference also to get public opinion. But while this is happening in the past month, we've also seen, which has divided public opinion, the Yakub memo hanging. I wanted to ask you, what did you think of the way that played out and the public opinion in that? What do you gauge of how because it divided everybody. Where do you stand on it?
It is very difficult to comment upon an individual case which has been decided by the Supreme Court finally, and Mr. Memon was executed. But I was struck by 2 or 3 aspects of the case which really troubled me. why this particular date was sacrosanct, why when there was a reference to the larger bench, the court did not consider grant of stay of the order, why the accused or the convict was not given an opportunity of challenging the rejection of mercy petition. So it's a established law that there can be more than one mercy petition. The earlier mercy petition was filed by his brother, and the second mercy petition was by the convict himself. So I'm not sure whether the result would have been different, but I think that due process ought to have been followed more scrupulously. Of course, we are all bound by the
and so there was new facts also, right? The column which came about where
yes.
he talks about his, B. Raman's stand on that. All of these were new things which should have been considered?
Apart from that, we must bear in mind that he was in jail for 21 years. He was under the shadow of death penalty right from the decision of the trial court. So after 21 years, I personally feel that this is also one of the considerations for deciding his mercy petition. But these are the decisions to be taken by the president and the government of the day, and the president has to act according to the aid and advice of the Council of Ministers. I must tell you that in this context, you see, from 1950 to 1973, more than 260 mercy petitions were filed with the president, right from starting from Rajendra Prasad up to say V.V. Giri and even thereafter. Out of those 260 odd petitions, only one mercy petition was rejected, and all mercy petitions were accepted, and the death penalty was commuted. But thereafter, there were different periods. For example, during the period of Mr. Jai Singh, Mr. Shankar Dayal Sharma, and I think there was one more, and most of the mercy petitions were rejected. And thereafter, when Mr. Narayanan and Mr. Kalam occupied the post of the president, they simply did not decide any mercy petition. So as a result, during the entire period, only 2 mercy petitions were decided, and out of 2, one was rejected by Mr. Kalam, and one was accepted. And again, there is a different pattern. So mercy power is supposed to be the ultimate protection. If there is anything goes wrong in the judicial adjudication, mercy power is the sovereign function, which reflects the national conscience. So which is the last chance for that prisoner. But even that mercy power is really cannot be said to be a protection in the sense that it again depends upon the personal dereliction.
Because are you saying what you said in your report, that both the deciding people, the government, the Council of Ministers, the President and the judges, they're all arbitrary?
No, I'm not saying arbitrary in that sense. Please do not misunderstand me. It's a system. In Bachchan Singh's case, the court said that it's only in the rarest of rare it should be done. And they said because it's a matter of really human dignity. You are going to put an end to the life. So in such cases, there has to be very rare exercise of this power. And they laid down some principles. But now the experience shows, this is what the judges are voicing, that death penalty jurisprudence is becoming just-centric. It is completely inconsistent, and the judges themselves use the term as that the exercise is arbitrary. It's completely inconsistent.
Okay.
So therefore, there is a need, and this is how the reference came to the Law Commission, that the judges felt that the Law Commission should look into it. And what we felt at the Commission, and this is our finding, that this rarest of the rare, that only in exceptional cases, this will not happen. There will not be a system to award death penalty which will be free from arbitrariness and freakishness. this is the conclusion.
Okay.
There is no other way in which the death penalty
So
can
in
be
fact,
executed.
Akansha is a very good question when we talk about the condition that you've left. Akansha, your question, yeah?
So my question is, when terrorists come to attack your country, they're already prepared and they have a mindset that they're ready to die. So how do you feel that the death penalty would act as a deterrent for them?
Let me just speak to you about the so-called deterrent theory. Our view is that deterrence theory is a myth. First I will explain about the ordinary crime.
Yeah.
This presupposes too many things. That the accused person who is about to commit the offence, he knows the exact punishment for this offences. Secondly, he knows that in all probability he is going to be hanged. So these were the ideas earlier, but if the empirical evidence is seen or the recent debate is seen, it is a conclusion, inevitable conclusion, that there is no deterrent effect of death penalty. It doesn't work that way. Insofar as terrorists are concerned, I mean, they are prepared to die. In fact, they solicit death penalty. You should, I don't know how many of you have seen that Bali bomber.
Yes, you mentioned
he
that
was,
in the report.
Yes, he was beaming in the court and with a thumbs up. I mean, so what really what they are seeking is martyrdom, and what we are really. I mean, somebody commented in the context of the.
So why did you leave it in?
No, the country is sharply divided on this issue, whether it should be done, and we felt that we should not adopt a course of a complete abolition in one go. Let's take the Britain example. In Great Britain, they decided to abolish death penalty in respect of some offences. They retained some offences. Then again they felt that it is really wrong. I mean, they said that a murder with a robbery,
yeah.
I mean, such things, they said that it should be retained. And then when it came to legislature again, they retained it only for waging of war, etc. And finally it was abolished. So we felt that perhaps this is the way for our country
Easier
to move in. Yes, of course.
Yes.
Of course.
Yes.
I can't deny that.
So I wanted to ask
I
you, you've already spoken very frankly about what you felt about the Yakub thing. I wanted to ask you about the previous one as well, which also divided a lot of people, which is the Afzal thing. Even now it's a very sensitive issue in the valley, sir, because of the way the family wasn't,
actually the court itself commented that the execution was carried out in a secretive manner, and then host of directions are laid down by Supreme Court, the conditions precedent before the execution. So that was unfortunate. I mean, his mercy petition was kept pending for number of years, and suddenly it is. And I would not be. I would say that these are mostly political reasons. That it was kept pending for a long time, and suddenly it was rejected, and he was immediately executed. Sometimes it has a serious repercussions, because that's an issue. But we feel very strongly that these issues about the terrorism and say the offences of waging war, etc., must be debated in Parliament. There should be more debate in the society.
So
should not be done.
One of the things that you mentioned in your report, which I find absolutely shocking, is that you say that between 2000 and 2013, at least 23% of cases, Supreme Court has itself admitted that they made errors in giving out the death sentence. Sir, in Britain, because you mentioned Britain before, I want to just point out, it took them just 2 cases to figure out they made a mistake. In 2 cases, they immediately abolished. By 60s, they had abolished the death sentence. How is it with 23% Supreme Court own admittance, we still are debating and you're still recommending and the government is yet to? Why is it that?
Let me explain to you what happened in those cases. See, in Bachan Singh, the court said that when the death penalty is awarded, the circumstances of the crime as well as circumstances of the criminal must be taken into consideration. This was subsequently by a smaller bench. They said circumstances of the accused are not relevant. And then much after those judgments were delivered, that judgment was followed, and finally in Bariyar the court said that all those executions were incorrect. They were erroneous. The 16 persons were sent to gallows, and this is an admitted position that their sentences ought not to have been given. But then this mistake was brought to the notice of the then President of India. Some 13 judges, including me, wrote letters that this is the Supreme Court itself is acknowledging the mistake, but nothing happens thereafter. But there are this possibility of error cannot be. This is possibility in awarding the death sentence, but there are possibilities where the very conviction may be wrong.
Yes.
Akshardham case, for example, the trial court convicted the so-called terrorist and awarded death penalty. The High Court, they confirmed the death penalty. 2 judges confirmed the death penalty. They are all trained judges. And what happened finally? The Supreme Court said that the evidence was cooked up, fabricated by Gujarat police, and they were acquitted.
Yeah.
So there is also a possibility of error. What I am saying is that this punishment is too final, too irreversible.
Yeah.
You can't do anything about it. So therefore, and by the way, I must explain that the Commission is not opposed to punishment. Commission is saying not death penalty, but a just punishment for heinous offences.
We are also hearing, sir, that the government has accepted your report on MAT. So that's happening right now as well. Is that something you expected?
It's
We're
for the
hoping
decision.
we're hoping the same goes for the death penalty report
Yes,
as well.
right.
So one thing before we take a break and then we come out, they have lots of questions, we move away from the death penalty, is that you're now retired from this. The Delhi Chief Minister, the Delhi government wanted you as a Lokayukt. Why did you say no?
See, I would say basically it's my personal reasons. So perhaps I felt that I'm not really cut out for that kind of a post when I personally see that there's a lot of friction between the state government and the center. The powers of the Lokayukt are very limited. Bureaucrats are not covered. Police is not covered.
So just because of the deep
No. It's my personal. No. Of course, it's not about the fight. It's about my personal decision. See, I had my stint in the High Court. I did something in the Law Commission. So the time has come whether I should be, and it's a more about the family life. It's not really not the rejection of the post. I must say that I was honored by this offer, but I felt that for my personal reasons I cannot accept.
And
it.
also what's the state of the center and
yes,
state. That's something for the Delhi government to consider. We'll take a short break now. When we come back on agenda, lots more things to ask Justice AP Shah. Stay with us. On agenda, we have Justice AP Shah, outgoing Law Commission Chief, who's just recommended that the death penalty should go except for in terror cases. We also have an audience of law school students who are dying to ask questions. What is your question? Yeah.
Sir, my question is, the former Chief Justice of India, P. Sadaswam, became the governor of Kerala. Don't you think and there was a big controversy regarding that, don't you think it raises a question regarding the judiciary itself, integrity of judiciary itself?
I expressed my opinion on this on more than one occasion. It's my view that there should be a cooling off period for judges, and they should not accept any appointment during the cooling off period. As I said earlier, that I was a bit disappointed that a retired Chief Justice of India has accepted a post of a governor, which is really, which is according to me, which ought not to be accepted by such a constitutional authority. And I have great respect for Justice Sadashivam.
Okay. Yeah, your question? Go ahead. Yeah.
Sir, as you have always supported equality, what role do you think Law Commission can play in ensuring equality to the LGBT community?
Are you really disappointed that what order you gave in 2009 hasn't come to...
You see, the NAS Foundation was reversed by the Supreme Court, and then there is some curative petition is pending. I thought that since it was my judgment, I should not be taking up this issue in the Law Commission. But incidentally, the High Court of Madras has passed an order. The High Court has implemented the Law Commission as well as the Union of India, and put some questions why there is a discrimination against the LGBT community.
Yeah.
But now I'm no longer there. So perhaps the next commission, next chairman would be dealing with this issue.
Your final question.
Sir, do you think India should introduce pecuniary punishment for criminal offences?
And also, sir, to that I just wanted to add, we've just noticed what happened in the Uphaar case. I know that, this is something which has broken the hearts of many families who are associated, and they just, after so long, even the Supreme Court upheld the conviction, nobody has been sentenced to go to jail. They just give a, like a compensation. What do you think of that?
Since you mentioned, she mentioned about Uphaar case, let me say, I have some views on that. Firstly, I feel that the Supreme Court in the earlier round of litigation was not right in reducing the compensation. These are the cases where the compensation should be exemplary.
Yes.
Because you send message to the society that if you don't take care, if you don't, there is a duty to take care and you fail, these are the consequences. Coming back to the second case, there is a lot of controversy on that. Whether we're taking the imprisonment has been, so that's a matter. But let me come to your question first. Whether there should be so you are saying instead of retributive, it should be a compensatory justice. So I feel that the compensation is not in the form of, it should be in the form of asking the accused to compensate the victims of the crime or their family members. There is no doubt about it. But that should not be a ground for reduction of a sentence of the accused. What I feel is that it is the responsibility of the state to prevent restitution of such families and to pay compensation to them. State should undertake the responsibility of compensating the victims.
So you've given us so many things to think about. Unfortunately, I know that many people had lots of questions, but we're totally out of time. Justice AP Shah, thank you so much, and
thank you.
Thanks for all your insights. Thanks for watching. Goodbye.